This 22-year-old appears in court accused of hitting and killing 4 sorority sisters in his speeding BMW that was gifted to him by his mom and dad. This video per KABC. This crash happened on the picturesque Pacific Highway on a stretch called Dead Man's Curve. I'll tell you why he's not just charged with causing a terrible accident in Malibu, an accident that killed these 4 girls, months away from their college graduation. He's charged with murder, and the attorney who's going to be by his side saying he's innocent.
There is no evidence that any officer at the scene ever heard Karen Reed say, "I hit him."
Is the same man who defended Karen Reed. Alan Jackson has taken the case. We're on the case, presented by Law&Crime. I'm Chris Stewart. If you followed the Karen Reed case, then you know the type of information that can be taken from a vehicle when it hits something or someone, and you also have seen the debate over whether or not that information could be trusted. This is video from KABC TV of 22-year-old Fraser Bohm entering a courtroom in Southern California to face 4 counts of murder. Now, as I said at the top, his new defense attorney is fresh off the not guilty verdict in the Karen Reed case, where she was accused of murder involving a car hitting a person, and in her case, it was her boyfriend, John O'Keefe, a Boston police officer.
Your sworn obligation under the law is to acquit Karen Reed, not just because you can, because you must. Justice demands it.
Let's dive into what Alan Jackson's new client is accused of. This is Fraser Bohm. He is now 22 years old. He was 20 years old at the time of this incident. He grew up in the beautiful and wealthy community of Malibu, California. Fraser was a baseball prospect from what we can tell. He used to play high school ball for the private school Oaks Christian Academy. Tuition there will run you $45,000 a year or more. In 2023, Fox News wrote that Fraser lived with his mom in a Malibu estate worth $8.7 million. And that car that is at the center of this story was a BMW that was given to him as an 18th birthday gift from his mom and dad. All of this just painting a picture for you of the tax bracket that this family and this defendant comes from. Here's what police say happened on the night of October 17th, 2023 in Malibu, not far from the beautiful campus of Pepperdine University. Police say Bohm was behind the wheel of his Beamer and he was going 104 miles per hour. The speed limit was 45. He was doing this along the Pacific Coast Highway, again, a very scenic but a dangerous stretch of road that runs right along the Pacific Ocean. Now, most of the pictures that we could find of the PCH today is after the wildfires that devastated Southern California and Malibu in January of this year. But as you look at this picture, you can understand the type of road that we're talking about. And on that night in 2023, Bohm was allegedly going more than twice the speed limit. These 4 girls were getting out of a car on the shoulder of the PCH. Before we get back to this episode of On the Case, which, by the way, is one of the most watched shows on YouTube, I want to talk about our partner and sponsor, Morgan & Morgan, America's largest injury law firm. They have more than 1,000 attorneys and a history of winning. They've recovered more than $25 billion from more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. In Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. And another client in Pennsylvania received $29 million after being offered only $500,000. Even if you don't think your case is worth millions of dollars, why not fight for what you deserve? Morgan & Morgan makes it so easy to start a claim. You can do it with just 8 easy clicks on your phone. So if you've been injured, you can start a claim by going to www.forthepeople.com/OTC. You can also scan the QR code on your screen or click the link below. And here are their pictures, and I want you to hear their names. 20-year-old Neem Rolston, 21-year-old Peyton Stewart, 21-year-old Asha Weir, and 21-year-old Deslyn Williams. The 4 girls were sorority sisters at Pepperdine, and they were seniors. In the spring, they were going to graduate and continue on with their lives. Police say Bohm hit them with his car, and all 4 girls died on scene. The area of the highway where Bohm hit them is known as Dead Man's Curve, and according to KABC, that stretch has the most auto accidents, several fatal, of any other part of the 21-mile highway. Bohm was arrested a week later, and here is the former district attorney of Los Angeles announcing his arrest.
We're here today to announce that we're charging Fraser Michael Bohm of Malibu with 4 counts of murder and 4 counts of gross vehicular manslaughter. He is being held on $4 million of bail.
But again, prosecutors say the deaths of these 4 girls, these sorority sisters, it was no accident. They say it was murder. This is a picture of Bohm from his most recent court appearance that happened last week in Los Angeles per KABC. He was supposed to be arraigned on those charges, but he brought in a big name attorney to defend him who requested more time to review this case. Now, if you followed the Karen Reed case, you know exactly who that attorney is. His name is Alan Jackson. I'm going to talk a little bit more about what Jackson's defense could look like in this case. But first, let's dive more into these allegations that his new client is facing.
On October 17th at around 8:30 p.m., Mr. Bohm was allegedly speeding at speeds of 104 miles an hour on a 45-mile-an-hour zone on PCH when he lost control of his BMW. He allegedly crashed into a parked car before crashing into 4 pedestrians standing together on the side of the roadway. All of the young women died at the scene. The investigation revealed that the defendant knew his actions were dangerous to human life and deliberately acted with conscious disregard for human life, committing 4 counts of implied malice murder in this case.
Prosecutors say that Bohm accelerated from 93 miles per hour to 104 miles per hour just 2.5 seconds before hitting the first 3 girls, according to data retrieved from the BMW's so-called black box. Now, Bohm's previous defense attorney had argued in previous hearings that the black box information should not be trusted. You can see some of the parallels here between the Karen Reed case and this case in Southern California. That defense attorney had said not only was Bohm going much slower than 104 miles per hour, he believed it to be around 70. He also argued that Bohm was going so fast because he was outrunning a road rage incident. Here's what we know about that alleged road rage incident that apparently happened seconds before this crash. A man named Victor Calandra could be a key witness if this case goes to trial. He is the person who was in this alleged, quote, road rage incident with Bohm. He said that he saw a vehicle driving erratically. Now, it's unclear whether he would consider it a road rage incident, but according to Pepperdine Graphic, the newspaper, here is what he says happened. Calandra said that when he and Bohm, after he saw him allegedly driving erratically, ended up next to each other at a stoplight, he looked over and he saw the 20-year-old at the time with a cell phone between his legs under the steering wheel, and he was possibly texting. He then allegedly spoke up and told Bohm, quote, "Hey, you need to be careful. You're going to hurt yourself." He says the light then turned green and Bohm gunned it. Seconds later, that BMW allegedly hit the 4 girls, killing them. Bohm also allegedly told investigators that hitting the 4 girls was a, quote, accident. He said that he had to swerve because he was trying to avoid a car that was right next to him so close that it actually had hit his driver's side mirror. Now, prosecutors have argued that they found the car that he was apparently talking about, and they say the car didn't have any damage. It was a white Honda Civic. The previous defense attorney for Bohm, the person before Alan Jackson took over this case, had also questioned just how quickly prosecutors filed a case against Fraser Bohm. They said that the charges came 4 days after the crash, but they say cases like this usually take 8 months to a year before charges are filed. Bohm has pleaded not guilty. Joining us now to talk about this case is Matthew Timpanek, criminal defense attorney. Thank you for taking the time to be with us here on Law and Crime. Before I get into the Alan Jackson part of it, which definitely caught our attention because of what he recently was able to do for Karen Reed, when you look at this case, what does the prosecution need to prove for this to actually be a murder conviction, not just manslaughter?
In a murder case, you have to show some kind of reckless disregard for human life, meaning that depraved indifference is second-degree murder. So if you're driving recklessly, weaving in and out of traffic, you're creating a substantial likelihood that you may lose control of the vehicle, that somebody may be injured. So your conduct needs to go past, it needs to be beyond egregious. It needs to be um, anybody, given the circumstances, should have foreseen that this could have happened. I think there was a case out of Michigan about 6 months ago where a lady drove into a birthday party. She was drunk,
Yeah.
and they convicted her of second degree murder because her conduct was so egregious. And the belief is that it was a depraved heart, depraved indifference situation, meaning that her driving as drunk as she was and as fast as she was put everybody in the community at large at substantial risk of injury or death.
Why is it different for a vehicle? Because when I think of second degree murder, if it's someone, say, with a gun, and in that moment they were mad and they clearly wanted to kill somebody and they shoot that person, that would be a second degree murder case. But here, it's unclear if Fraser Bohm, potentially didn't go out that night thinking he was going to kill four people. He didn't know these four students. He wasn't, targeting them specifically. Why is it in a car that it can be considered a murder case where it feels like, and I'm not a lawyer, but on the outside, that wouldn't be the case if it was not involving a vehicle?
Remember, a vehicle is a deadly weapon itself. So you think of a deadly weapon, the first thing you think of is a firearm. But a vehicle can also be a deadly weapon because you have a 6,000-pound vehicle that has the ability to bulldoze over any human being it comes across. So when you think of why it would be murder, you got to remember that when he's driving, the allegations are he's weaving in and out of traffic. I think he was going something like between 93 and 110 miles an hour in a 45 zone. Another driver actually saw him driving erratically, weaving in and out of traffic, and then they made contact at a light. So you put all those facts together, and that's how you're creating this conduct goes beyond manslaughter. It's not he wasn't intoxicated. It wasn't that it was some kind of accident. His conduct was so egregious, driving double the speed limit, that anybody, especially somebody given his young age, not a professional driver on a closed course, but somebody who literally did not have the skills to be able to do that, as nobody should be driving that fast. It's not like he was going 65 in a 45 and lost control. He's going double the speed limit. And by doing so, that is what creates this depraved indifference situation for murder, too.
I'm interested to get your thoughts too on the black box, apparently, when we think about the speed and what that may show, how it could factor into it. But let's talk about Alan Jackson because he's fresh in the mind of so many people. When I saw he was taking over this case, I was like, this guy does not take a break. Like if you would think the stress of a trial that he went through for Karen Reed for so long, I'd be on a beach for a long period of time, but he's getting back into the game. What does it tell you about the family of Fraser Bohm when you go and get someone like Alan Jackson for a case like this?
When you go and get Alan Jackson, you got to have substantial finances to be able to do this, because to get him off of a case that he spent the last year and a half of his life pretty much thinking about every single day, the fee had to have been tremendous. And it's his specialized knowledge of accident reconstruction. It is very likely that he's going to argue something similar that he did in the Karen Reed case, or it's like the black box is wrong. And here are our experts saying that, because they have the witnesses. They're not going to be able to be like, there was no collision here. That's not going to be the defense. It's going to be the data is wrong. And here is why. Because if they can get it so the speed is substantially less, then that has the ability to mitigate the murder two charge. Because as it stands, 90 to 100 miles an hour in a 45 zone, 4 dead sorority girls from Pepperdine University, that doesn't have jury appeal. But if the black box information is faulty, that could be grounds for mitigation or even reasonable doubt.
Yeah, because the prosecution has argued in the past with Fraser Bohm's previous defense attorney. He's now being represented by Alan Jackson. But in the past, the prosecution has said that 2.5 seconds before hitting 3 of the sorority girls, Fraser he had accelerated actually from 93 to 104 miles per hour. And then the defense in the past had argued against that. Based off, for so many of us who now know a lot more about the information you can get from a vehicle post Karen Reed than maybe we did before, what is it about the black box that Alan Jackson could point to and attack and use as his defense? Why is a black box not as accurate at times? At least the defense will argue that as much as the prosecution wants people to believe.
Because when you have an accident reconstructionist, so what he's going to do from here is he's going to hire an accident reconstructionist to explain why the black box information is faulty. As we saw in the Karen Reed trial, where she's like, the data is the data. That's not going to be what he's going to argue here, because if he does, then it's 2.5 seconds right before this occurs. He accelerates. I think his previous attorney had stated that he was fleeing from a road rage incident,
Right.
and that's what he was trying to get away from. But when you're trying to argue it as a defense lawyer, you need to figure out what is the aggravation, which would be the speed, but also how can we, that is the aggravation. What is the mitigation? How do we minimize that information? That it's like, oh, well, it was hurt so much in the wreck that the information provided, the numbers are all out of the place. And that's what he's going to try to do is like, oh, at this moment, the numbers should have been this. But it's saying it's this, like, we can't really trust this data. It was so badly damaged from this horrific crash. I think that's where he's going to try to go, in addition to having his own accident reconstructionist and having a somebody pull the data and saying, like I said, it's wrong.
What do you make of the witness? The main witness in this case is this man who said that he had witnessed Fraser Bohm driving erratically, and then they were at a stoplight, and apparently he had said something along the lines of like, "You need to slow down. You're going to hurt somebody." And then after the light goes green, Fraser takes off. He says, and then this terrible crash ends up happening. As a defense attorney, how do you go at someone who is telling this story that doesn't look good for your client?
I think what you need to do is talk about what his mental state was. What time of day was it? Was the individual consuming drinks right before? What kind of stress the situation? Are you just remembering what you potentially could have said? Are there witnesses for you saying that? Because you saying that now doesn't mean that you said it then. And you could be just trying to it's almost like a regret, like I should have said this, but now I'm saying it in court because for those 4 victims. That's what you're going to need to try to do. It's like, just because he's saying this now doesn't mean he said that on the day in question.
And I know in the past that this witness has said that he saw Fraser looking down, his phone appeared to be between his legs, and that he was texting. If that story comes out in court and you talk about the intent part of it and trying to show that what he was doing was so egregious that this wasn't manslaughter, this was murder, the texting part of it, how critical is that to what the prosecution is going to try to argue?
Because what they're going to need to do, they're going to need to subpoena his cell phone provider and make sure at the time, because they have a time frame of when this happened. They're going to have text messages, because in other cases, I reviewed text messages where it has timing. It's not really what it says. It's like, oh, text message sent at this time, or read receipt at this time. If they can get that data and show that he was texting at the time, then it's not just some, oh, I lost control of the vehicle. Now it's a texting and driving situation. That has been an epidemic, especially on Pacific Coast Highway, which I think I saw something like 40 people have died in kind of traffic crashes in the last like 7-8 years or something like that. And that's something that's going to appeal to the jury. Because when you're the prosecution, you got to make the jury feel like it's their duty to hold this guy accountable. And when they hear that how fast he was going, somebody told him that he needed to slow down, it was going to hurt somebody, and they have evidence from the black box about how fast he was going, and finally that he was texting and driving, that's more than enough to make a murder 2 case.
And as you're talking about kind of getting the cell phone records, making another Karen Reed kind of comparison is to the how long does it take to die into the cold, and the argument over when was that actually Jen McCabe had typed that into Google or whatever it was. When it comes to cell phone records, how accurate are those? And if you were a defense attorney and maybe it shows that right around that time of impact that Fraser Bohm was sending a text, how can you argue against that?
That would be very difficult to argue around, because that's something that goes to the whole theory of the case. That was something when you think about what was presented in the first trial, where Shannon Burgess testified in, I mean, not in the first trial, in the Karen Reed trial,
Yeah.
that Shannon Burgess testified about the black box data, and then it was testified about the cell phone data. So you're almost doing digital forensics to be able to prove that. And as a defense attorney, you need to figure out, it's like, okay, where are the holes in this? Are there was in the extraction? Is there in the interpretation? That's what you need to do. Your job is not to, don't have to disprove anything, but you need to poke holes in the theory about it, and how, whether it during its extraction or whether it's interpretation, because otherwise it doesn't look good for the defendant.
Alan Jackson, definitely coming off of Karen Reed, very well known to a lot of people across the country. There are probably going to be jurors that are going to recognize him if this does end up going to trial. You're a criminal defense attorney. What does he do well that makes him one of the best?
He has the ability to control the courtroom, demand attention from the jurors. Now, when he speaks, they listen. So when he needs to keep that going in this case. He's not going to try the same case he did in Karen Reed. He's not going to have like the same there was no collision. But his whole thing is finding the biggest aggravation in the prosecution's case, and attack it, and try to leave nothing left of it. In the case involving Karen Reed, the most powerful piece of evidence was the tail light, and the tail light data embedded in John O'Keefe's clothing, the tail light at the scene. But when the jurors went to go deliberate, they were talking about the pieces of the tail light wasn't missing at 504 based on the color. So what Alan Jackson does best is take the strongest piece of evidence and attack it and try to minimize it, because if the jury thinks that that was potentially the strongest piece of evidence, maybe everything else isn't as strong either. A smart opponent always hits its opponent where they think they are most safe. And that's exactly what Alan Jackson is likely going to do with this case.
Because when I look at this case too, and this is more of how it's playing out thus far in the court of public opinion, it's this 20-year-old kid at the time. He's 22, 23 years old now. He's driving a BMW that his parents gave him as an 18th birthday gift. He's incredibly wealthy. And then here are these four sorority girls who were set to graduate college. They were all going to go off and have successful careers. What challenge does Alan Jackson face with kind of getting the spoiled kid label that is going to be put on Fraser Bohm, getting that tossed away, and then, really looking at a crash that there's no doubt the crash happened, but just in terms of, maybe not as much the facts, but controlling the courtroom when your client is someone who a juror might look at and have a negative opinion of, just hearing about who they are from the very beginning.
So this is a very important part. With the Karen, like the parallels between the two
Yeah.
cases. The Karen Reed case was won and lost during jury selection. I think that many of the jurors were not people the prosecution would have picked if they were given a second chance. So when you're thinking about how are you going to kind of massage the rich kid image of the defendant, and I don't know if necessarily you're going to be able to do that. But what you can do is you put people on the jury who are wealthy and affluent, like the defendant, so that they can sympathize for him. It's like, okay, this kid made a mistake, in the hopes of mitigating it. Because if you're getting a bunch of people who didn't grow up in Malibu, didn't grow up getting kids a BMW for their 18th birthday or whatever it is, that jury's going to have no sympathy, and they're not going to hear anything that I have to say. They'll follow their oath, but they'll find him guilty of something, very likely. But what you need to find is people who can sympathize with the defendant, which is going to be difficult, because you on the jury, you have four dead sorority girls who were just posthumously awarded degrees. How is that going to jive if you let this rich kid off because his attorney tried to basically gaslight you into thinking the data is not the data? So I think that in jury selection is going to be the most important, to be able to find those jurors who can sympathize with the defendant.
And then just lastly, I mean, we have a long way to go if and when this eventually gets to trial. Who knows if there's a plea deal or something like that. But if this does go to trial, how strong of a case, from what we know at this point, does the prosecution have?
It's a pretty strong case. With the black box data, the witness, the aggravation, going between 93 and 110 miles an hour, somebody who's very young, inexperienced, driving, and that it seems like there was no, he was not in some kind of road rage incident. If he's texting and driving, it's a very strong case. But like I said, that's why we have due process. That's why everybody's presumed innocent until proven guilty. But as it stands right now, unless Alan Jackson is able to poke substantial holes in the strongest evidence, it's a very, very strong case, and not circumstantial either.
Yeah, we'll see how it all plays out. Matthew Timpanic, criminal defense attorney. It's great to have you on Law and Crime. Thanks for joining us.
Thank you.
Now, Alan Jackson requested 30 days to be able to review this case, postponing the arraignment of Fraser Bohm. He is due back in court in early August. He is out on $4 million bond. As for the victims in this case, all 4 girls received degrees posthumously from Pepperdine University. That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.